appeal, where they have given the judgment, single judgment in case of the 11 appeals filed by the different customers. So now this is the topic we will cover in 4 parts: issue, law, RERA High Court and ratio descendi. So first issue was before the Mah.Real Appellate Tribunal was that obligation of the promoter regarding the veracity of the advertisement and prospectus issued. So what was the issue? Whether the obligation of the promoter is prospectively or retrospectively or retroactively. This was the major issue before the Mah.Real Appellate Tribunal, that how to decide the obligation of the promoter when the promoter has issued the advertisement before RERA was implemented in 2017. So this was the very big issue and important issue. Second issue was there, right of the allotee. When the obligation of the promoter is decided, then what would be the right of the allotee? Whether allotee will be entitled for the refund along with interest or compensation. So these two major issues were decided by the Maharashtra Appellate Tribunal in this landmark judgment. So before understanding the issue, or we have to understand the concept or what are the provisions talks about related to advertisement. So in the section 12 of the RERA, so I'll repeat again, what is the obligation of the promoter when any promoter has issued any advertisement, has issued any notice, has shown any model apartment, and on the basis of that information, on the basis of that model apartment, suppose any customers visit the site of the promoter and he confirm the booking, he take the decision to take the booking in that particular project, or he makes any advances, and later on, suppose that allotee find that the information whatever given in the advertisement notice or any project specification as shown in the model apartment, that was not the correct, or that information was false, and due to that false information, suppose the allotee sustains any loss or he incurred any loss, then that allotee has a right to cancel. He can cancel for that apartment booking, or he can withdraw from that project. So in that case, what will be the obligation of the promoter? Whether he has to compensate the allotee, whether he has to refund the amount, whether he has to refund the amount with interest or penalty. So that is the provisions talks about the obligation of the promoter regarding veracity of the advertisement, and that is contained in section 12 of the RERA. So these are the explanation. I have already explained this. Now we will go with so this section 18 of the RERA talks about return of the amount and compensation. These sections I will read line and then I will explain also. If the promoter fails to complete or unable to give the possession of apartment. So this section says promoter is failed to give the possession in two situations. First situation is that first situation talks about when the promoter fails to give the possession as per agreement to sale. So whatever the terms and conditions mentioned in the agreement to sale, including the date of possession. Suppose the promoter has promised and he has executed any agreement to sale, and that agreement to sale he has mentioned any date, particular date to give the possession, and on that date if he fails to give the possession, then what would be the situation, or what will be the position of the allotee, and what will be the consequences of in that case? That's section 18 talks about that. Further, if the promoter fails to give the possession due to discontinuation of his business as a developer on account of suspension or revocation of his registration. Suppose any registration of the promoter, whatever the registration he has made under the RERA, if that is cancelled or it is revoked, or the business has been suspended, then in that case promoter will not be able to give the possession of the flat as per the date decided between the allotee and the promoter. So what would be the consequences? In this case, there are two options. Either allotee may claim the interest from the promoter for the default, for the delay in possession, or either if the allotee wish, he can withdraw from the project, he can go for the cancellation of the booking. So this is the section talks about the return of the amount and compensation because of failure on the part of the promoter to deliver the flat on time, to deliver the possession of the flat on time. So these are the explanation I have shown here. This section provides the two situations where promoter is liable to pay the interest to the allottee due to failure to give the possession. First situation, when the promoter fails to give the possession as per the terms of agreement and including the date of possession. So therefore, it is a duty of the promoter to give the possession whatever the date it is mentioned in the agreement to sale. Second situation talks about when the promoter failed to give the possession due to discontinuation of the business. In both the situation, promoter has to give the interest for delay possession or refund of the amount if allottee is to cancel the booking. Now, these are the provision related to RERA. Now we will go into the fact of the case. What is the fact of the case? The promoter, Bombay Dyeing Manufacturing Company Limited, is developing a project, Iceland City Center in Wadala, Mumbai. In that case, promoter has issued the brochure, advertisement and prospectus. Promoter has promised, by issuing the advertisement, promoter has promised that he will give the luxurious facility in the project, world-class infrastructure would be there, 8 acres of lush green landscape would be there, and one important thing is that the possession will be given in 2017. That was the promise made by the promoter. On the basis of this promise or in the basis of this advertisement and prospectus information, the allottee booked the apartment in 2012 and 13. When the allottee books the apartment in 2012 and 13, the promoter has issued the allotment letter. They have issued the allotment letter. Along with the allotment letter, they have attached the specification of the project also. Apart from that specification, they have said that what the amount they have to give advance, what the earnest money deposit they have to give. On the basis of this advertisement and allotment letter, all of the allottee has paid almost more than 2 crore rupees. That was the 19% of the flat price. And this booking was done under the scheme of 2080, where 20% money has to given by the allottee and 80% money is to given at the time of possession. So all the allottee has paid more than 2 crore rupees, that is approximately 90% amount. However, the situation was that in the 2017, the promoter could not given the possession of the apartment. Apart from the failure to give the possession, the allottee noticed that the promoter has changed the layout plan. Promoter has changed the amenities. They have reduced the amenities inside the apartment also. Further, when May 2017 RERA came, at that time promoter has registered the project with the Mah.Real Authority, and at the time of registration they have mentioned that the project will be completed by 31st August 2018, and later on the date was revised to 31st August 2019. So by this date, the promoter has said that they will give the possession in 2019. So this was the fact of the case. Now agreed with these things, all the allottee, because they did not get the possession in 2017, they complained with the Maharashtra RERA authority that please give us the refund because we don't want to continue with the booking and we want to cancel the allotment letter. In that case, Mah.Real order, Honorable Chairman of the Mah.Real had issued the order. What is the content of that order? Obligation of the promoter regarding the veracity of advertisement or brochure does not apply retrospectively. This was the very important thing they have said. This is whatever the advertisement issued, that advertisement was issued in 2012-13. So they have said this advertisement obligation of the promoter is not apply retrospectively. Another point was that provision of the RERA do not apply to the present transaction. What Mah.Real authority has decided, because the RERA has came into 2017 and that was applicable from 1st May 2017 and the booking was done in 2012-13. So and the advertisement was also issued in 2012-13. So the provision of the RERA is not applicable. Further, Mah.Real authority has asked the allottee and they have ordered the allottee that you execute the agreement to sell as per the rules and regulation of the RERA. Further, if they don't want to execute the agreement to sell, then the booking may be cancelled, but that will be as per the terms and condition of the allotment letter. So the booking will not be cancelled as per the provision of the RERA. It will be cancelled as per the agreement to, it will be cancelled as per the allotment letter terms and conditions. By deciding this order, Mah.Real has observed that promoter can give the possession of the flat as per timeline declared, that is August 2019. So what Mah.Real authority has said, because the promoter has mentioned the project date of completion of the project date is 31st August 2019. So it is duty of the promoter to give the possession by 31st August 2019. It is not duty of the promoter to give the possession by 2017. Further, Mah.Real observed that suppose promoter cancel the booking, then he has to refund the money to all the allotee. And there are a 520 allotee in the project. So suppose one customer comes and he cancel the booking, then obviously there would be another complaints and everyone will get the refund. So Mah.Real Honorable Chairman has observed that this may affect the execution of the project and it will have a huge implication on the chairman of the, promoter of the project. So they decided that this cancellation booking cannot be cancelled and the allotee has to execute the agreement to sell. So this order was passed by the Honorable Chairman Mah.Real. By aggrieved this order, next slide please. By aggrieved this order, all the allotee, and there was a 11 appeals to the Appellate Tribunal. They appealed to the, they went for the appeal before the Appellate Tribunal, Mah.Real Appellate Tribunal. And what was the ground of the appeal? The ground of the appeal was that Mah.Real had considered only and only one part of the provision of the RERA, that was regarding the veracity, obligation of the promoter regarding the veracity of the project. However, Mah.Real authority has not considered that promoter failed to give the possession as promised by him. And they have not considered the provision of section 18 where it talks about that in case of delay possession, allotee can get the refund of the amount along with the interest and penalty. Further, they have observed that in one of the landmark judgment, Nilkamal Realtor versus Union of India, they have, the Mah.Real authority has not considered the view taken in this case. In this case, the Honorable Bombay High Court held that section 18 of the RERA is applicable retroactively. So this concept was not observed by the Honorable Chairman of the Mah.Real. On this basis, all the allotee filed the appeal before the Honorable Tribunal. Now we will understand what is the concept of the retroactively or retrospectively. Retrospective or retroactively concept is, we can understand this concept of the retrospectively and retrospective by two important judgment. In one of the case, everybody must be aware about the Vodafone case. So in Vodafone case, what happened? There was some shared sale transaction. In that case, tax implication was there, and in that case, the income tax was amended retrospectively. So the provision which applicable from backdate means the law has changed from the backdate. That is the meaning of the, in simple short, that is the meaning of the retrospective. And what is the meaning of retroactive? Retroactive meaning is not defined anywhere. However, retrospective is defined, but retroactive is not defined anywhere. But in simple terminology, I have written here that the first concept, there are two concepts to understand the retroactive meaning. First concept is that which may be called true retroactive, consists of in the application of new rules of law to an act or transaction which was completed before the rule was promulgated. It means that law will give the effect to all backdated transactions. So when retroactively is applicable, it means that whatever the rules, whatever the act, whatever the provision of the act has come, that will give the effect to the backdated transaction. So in that Nilkamal Realtor case, the same thing was observed, that RERA even has came into the picture from 1st May 2017. But whatever the transaction has happened before 2017 will also come into the picture, and that will applicable there also. So this is the meaning of retrospective and retroactively. So that's why in the case of section 12 and 18 of the RERA, this is applicable retroactive, not retrospective or prospective. This was the concept, and this was the decision taken by the Bombay High Court also. So now what is the order of the Appellate Tribunal? Whether section 12 of RERA apply prospectively, retrospectively or retroactively. So this is decision taken by the Mah.Real Appellate Tribunal. This section 12 is applicable retroactively. Whether promoter committed breach of section 12 and 18? Yes, because this provision applicable retroactively, so that it is by default that promoter has breached the section 12 and section 18 of the RERA. Whether LOT are entitled for the refund along with the interest and compensation? Yes, LOT are entitled for the refund and interest only. They have not said that they will get the compensation. What my personal view is that in that case, why they have not levy the penalty or compensation, why it is not provided? Because there was no major loss. Only that they have considered the interest, because whatever the fund given by the LOT to the promoter, that was utilized by the promoter and the LOT could not utilize that fund. That's why the Mah.Real Appellate Tribunal has given the judgment that LOT will be entitled for the refund along with interest. One another important things in this order was that the Appellate Tribunal has given the order that LOT will get the tax amount also, whatever the weight amount, Maharashtra value-added tax, and whatever the service tax paid by the LOT, they will get the refund of that amount also. That was decided by the Mah.Real Appellate Tribunal. Now, in conclusion, we'll understand the whole picture here. Section 3, which is of the registration of the project, which talks about the registration of the project. It says that any project which is ongoing as on date of the RERA has come into picture, that is 1st May 2017. Every ongoing project, if the BU permission, building completion certificate, BU permission has not received, that project has to get registered under the RERA. So, Mah.Real Appellate Tribunal has observed that section 3 is applicable for the ongoing project, means all other provisions, that is section 12, 18, any other section of the RERA will also applicable to the ongoing project. Further, RERA provision enable the promoter to decide the timeline to complete the project, but possession of the flat is to be given as per agreement to sell. So what does it mean? When you are applying for the registration of the registration under RERA, you have to decide the timeline, that on what date the project will be completed. By that date, you have to complete the project, but it does not mean, suppose you have given the you have made the promise to deliver the flat on particular date, which is before the completion of the project, then you have to give the possession on particular that date only. Further, the extension provision, we say that in case of there is a delay in a project, you may extend the project. That provision is to avoid the penal consequences from any non-compliance of or non-compliance of the formality in the RERA. So it does not mean that you will avoid the terms and condition of the agreement to sell. Further, provision of RERA do not rewrite the clause of agreement to sell. It said whatever the clause is mentioned in the agreement sale, you have to give the possession, you have to deliver the possession according to the agreement to sale. Further, they have said interest payable as per section 18 of the RERA is not penalty, as it is a compensatory in nature. Why it is in compensatory in nature? Because due to delay in possession, LOT is deprived of the use of the fund paid by him, and that fund is paid to promoter. So promoter is liable to pay the interest for utilization of the fund paid by the LOT. Last thing is that the liability of the promoter to compensate and refund of the amount along with interest due to incorrect false information in the brochure and delay or failure to give the possession as per agreement for sale are not retrospective in nature, and the same are compensatory in nature. Therefore, it is retroactively applicable. So this was the conclusion, and from my side, this is the things regarding the crux of the landmark judgment given by the Mah.Real Appellate Tribunal. Again, thanks. If